fly so high. Feet on the ground, but I still get by. The rules were made for someone else to try, but not me, not me. They said slow down, son, take your time. But I was born running every stop sign. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Every doubt just feeds a flame. Every scar reminds me why I came. I've been broke, I've been blessed, carry faith in an empty chest till now. The stars are down like good old friends, saying, boy, don't stop where the sky just ends. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight.
Welcome to another day and another show. Again, I would like to welcome all the new subscribers to this channel. Welcome to the channel, welcome to my platform, and welcome to my family. Now, 14 months ago, when I restarted this channel, there was just me, myself, and Trin, two people. In 14 months, we have gone from 2 people to 159 people. I am sitting at 26,000 watch time hours, or not watch time hours, I'm sitting at 26,000 views and 2,000 watch time hours in just a year's time, 14 months' time. Imagine what we can I bet you we hit close to 3,000 watch time hours before the end of this. We hit the 3,000 watch time hours before the end of this year. I guarantee you. And that's only 4 months away. We might not hit it. Damn trucks. Jesus. Damn trucks are so loud. Think you can make any more freaking noise? Jesus. Yeah, I believe we could get, or we will get close to 3,000 watch time. With the number of people that are watching, I'm actually looking at the views of a lot of videos and a lot of content. And this stuff is getting a lot of views and a lot of content. I noticed that the scanner feed has been getting a lot of views lately. But you know, normally I wouldn't care about the numbers because I'm not monetized. I don't have 1,000 subscribers on this channel. Yeah, exactly. Trash truck. The city likes to make noise, don't they? Um, Normally I wouldn't care, but I've noticed that the last month we last month we gained 4 new subscribers. We were up to 155 at the end of July, and we gained 4 new subscribers just in the recent weeks in August. So that's good. I appreciate you guys subscribing to the channel, and I do, I appreciate you wanting to be part of the community. If you have any questions, please let me know. My email address is uh, what was I saying? Linda's throwing me off track. Um, what was I gonna say? Oh no, I forgot what the hell I was gonna say. Uh, yeah, I just noticed that the live stream, the scanning, sometimes those scanning live feeds get a lot of views. Sometimes they don't get a lot of views. But sometimes they get, and the rewatch get a lot of views. A lot of the court stuff, some of the court stuff is getting good views. The numbers with the court stuff is actually starting to climb up a little bit. Like I said, I'm almost at 26. I'm at 26,000 views. And see, that's where you make your mistake, Michelle. You have the 1,000 subscribers that you need. Now you need to put content on that channel of yours and keep it on there. That 1 minute video or a 10-minute video that she did had over 1,000 views. That's a good start. But if you delete the content that you're putting on there, you're losing your watch time and you're losing your views. So please, you might want to talk to Tug or somebody else. But we've been doing this for a long time. Myself, haven't been doing it as long as Tug and Megan. I've only been doing it for 10 years. But trust me when I say you need to put your content when you put your live streams. You need to leave your live streams up. Let it get the watch time and the views. Because when you remove your content, like a live stream, you lose the views and the watch time that you had on that. So you made a mistake. Leave it. Oh boy. It's a rough life being a YouTuber. All right. So let's get to Judge Middleton's docket. It's like I said, Michelle, and that goes for anybody who listens to this channel who said that they want to create a YouTube channel. If you make a live stream, leave it up because if you're just starting out. Now she has 1,000 subscribers. She wanted 1,000 subscribers. She got the 1,000 subscribers. Now you need to start putting forth the effort to put content on your channel. And you need to leave that content on your channel. Don't delete it. Because when you delete it, it's like I said, you lose the views and any watch time hours. Okay, you have 1,000 subscribers. You have to have 4,000 watch time hours to be fully monetized. Fortunately for me, when I stream on Rumble, I'm monetized on Rumble. So as we are doing this live stream today, we are streaming on YouTube and we are streaming on the Rumble side. But you need to leave your content on your channel, Michelle, Stop deleting it. If you keep deleting it, you're never going to achieve the goal that you want, and that is to be a fully monetized channel. Me, I don't care. I'm 900 and 800 something subscribers away from ever being fully monetized. I'll probably never reach that goal in my lifetime. But let's get started with Judge Middleton. Enough of me yapping.
Matt, did you see any fireworks?
Yeah, we set them off over at Long Lake.
Okay. Shoot them over the Cass County line, shoot them that way.
It was very close. I think, where's the line? Like the launch?
It's somewhere, you could probably throw a baseball from
Yeah, we were
there.
probably a couple hundred yards away.
Right, shoot them over in Cass County.
And you know what, Linda? I didn't mute my mic. But you know what?
All
I
right,
believe
we're
that
going to
too.
go back live. Mr. Bush is here.
I believe that too. That she doesn't care. She dirty deletes just like everybody else does. Oh, and Felisa, if you're watching from Felisa's side, maybe you need to subscribe to this channel and learn how actual court works. And that these judges don't put up with the kind of bullshit that you do.
Here, he's met with one client, he's meeting with the other. And we'll be starting here in just a moment. We have 2 drinking driving sentences. Priscilla Walton inherited one and Matt Huff inherited the other. This will be the swan song for our visitors for a while. They'll be headed back to wonderful California for a few months.
This minimizer bra lets me choose.
All right, let's start with Michelle Scarberry, and then we'll do Tiffany Tincher. Good morning.
Good morning, sir.
You're Michelle Scarberry?
Yes.
We've met, you're here today on a charge of operating while intoxicated and possession of a firearm while intoxicated. They reduced the operating while intoxicated to impaired and then held the line at the firearm charge, which will require forfeiture of the firearm. You're here with your lawyer, Mr. John Bush. Priscilla Walton has prepared the screening report in this case. There we go. And we're ready to proceed. This is People versus Michelle Lynn Scarberry, 26582 SD. Here with the lawyer, Mr. John Bush. Mr. Bush, what would you like us to know?
The one correction she would have to the background is she shared with me she's worked at NEO since November of 2023. The report says 2025. I'm sure it's just a typo error.
Thank you. Any other corrections?
No.
All right. What would you like me to know?
Michelle's been very, very responsible in my dealings with her. She's I think very remorseful for what happened. I know she wants to explain that to you today in person. She's got a lot going on in her life, and I think she's going to be making good decisions. And I think the victim impact panel would be sufficient education to her to make sure we don't have an incident like this again.
Abby, you have any input on this one other than the original plea offer?
Your Honor, I agree with the recommendation. I would just add that I think a term of probation would be appropriate. Ms. Scarberry, she was twice the legal limit. She was a .16 and she had a firearm in her possession. She didn't disclose that until the officer asked. So I think that is reasonable grounds to depart from just fines and costs.
All right, Priscilla, you got this one. Let me tell you right off the bat, I think you had more than 6 White Claws. People often, almost always, minimize the amount of alcohol that they drank. 6 White Claws probably is not going to get you to a .159 or whatever what it was here, 156, about 2 times over the legal limit. So that's a bit of a concern. Very often, people also have marijuana in their system. You don't, as far as I can tell, you don't have any history of marijuana use. You got 0 criminal record. This was all a regrettable incident. There is a statute that says there's a presumption that there is no jail or probation in certain misdemeanor cases, unless there are serious misdemeanors. And in order for a drinking driving case to be a serious misdemeanor, there has to be some sort of accident. Now, the presumption can be overcome by other factors like the one cited by the prosecutor. You got a gun and you got 2 times the legal limit. There's also a case from the city of Auburn Hills that says in misdemeanor cases, we're supposed to sentence people proportionally. I'm not exactly sure what that means, but in that particular jurisdiction, they gave everybody jail time. And the defense appellate counsel went into all the cases that came before it and found that there wasn't really a lot of discretion being imposed in some of these sentences. So we're stuck with that case. I don't really know what it means, but we try to take that into consideration. Priscilla, you've recommended some deferred jail, but not a probation. The deferred would be if she completed the victim impact panel.
Correct, Your Honor.
Ms. Scarberry, what would you like me to know?
That it was a one-time really stupid decision that I made, and I want to put this past me, and it was just really stupid.
Tell the judge if you.
That's it. And I haven't drank since the incident either. I'm not a big drinker anyways, but I haven't.
This flashes into my head often.
Hey, put this on!
I'm gonna go down a slippery slope here. Our sheriff got arrested for drunk driving at .21. He crashed into another vehicle. was driving too fast, was very intoxicated, driving a county vehicle, and he had a gun. He had his duty weapon. Now, this happened, I believe, on the Kalamazoo County side of the line. I can't remember, it was our side. Anyway, the matter was handled by the Kalamazoo County District Court. He got 1 day in jail and a probation. And they said, well, that's just another day in the quote, that's just another day in Kalamazoo County. So you have no accident. You're polite, respectful to the officers. You have no previous criminal record. Your driving wasn't that bad. You weaved a little bit, but you were 2 times the legal limit. So the difference between your case and that case was a probation. Now, that case wasn't in St. Joseph County. If it had been in St. Joseph County, that would not have been the sentence. But that's what it was in that case. The gun was a little screwy, not because of anything you did, but somehow the serial number got transposed and the ownership of the gun wasn't quite clear. Tell me about the gun. What are you doing with that?
I keep it in my car. I have a magnetic holder under the seat. It's what I carry, but I don't have it on me. I just keep it in my car. And again, stupid, didn't even think about it.
Yes. And you weren't doing anything untoward with it. You were, but you can't carry it when you're 2x drunk. So that would be one of the factors that would mitigate toward a probation. But you're not drinking. You have no criminal record. The driving wasn't bad. You weren't doing anything untoward with the gun. Your car got towed, which cost you several $100s, and you're going to forfeit this gun. And I don't see the need to do a probation. But on the impaired, I'm going to order 2 days jail, credit 1, leaving 1 day to serve, which is deferred for your completion of the anger management, the victim impact panel. It's an expensive process. It's a $300 fine, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee. This was White Pigeon. Did they do the?
120, Your Honor.
That was in the police report rather than the. Set all that up, and the victim impact panel was $32. $827. Let me add that again. 300 plus 125 plus $100 screening fee plus $150 for a portion of your attorney fees, $120 police reimbursement, $32 to pay for the class is $827. I don't have any bond. On the possession of firearm while intoxicated. How much did it cost you to get your car out?
$450.
Plus you're gonna lose the gun. In the firearm case, 1 day credit 1, firearm and ammunition are forfeited. Concurrent with the impaired.
Check this out. I'm going to show you how I afford.
I say this a lot, and we tend to forget about people like you. I get several hundred drinking driving cases a year. Times 47 years is a lot of drinking driving cases. And the vast majority of them never come back. And we lose track of them because the people that come back over and over again. But it's embarrassing, it's humiliating, it's expensive. It's like, I don't ever want to do that again. And most of them don't. And you're going to be one of those. You're not going to do this again. I'm not going to see you in here again. Which is why I just followed the recommendation. Sorry, I want you to go with Ms. Walton. She will explain what you need to do to complete this. Now, I didn't give you a time frame. How much time do you need to pay that fine?
I can pay 500 today.
All right.
And then if you just give me a date, I can pay the rest.
All right, Priscilla, will you take care of that too? All right, good luck to you, Ms. Scarberry. I might see you at Myers or something, but I don't expect to see you in here. All right, Abby's taking her leave. This next case is an ordinance case. Tiffany Tincher. This one, I don't know what to do. Mr. Huff has inherited this. Prepared a screening report for us. This Tincher was charged with operating with a while intoxicated. The prosecutor agreed not to charge high blood alcohol level. She was very intoxicated, now out of control. And I don't know what to do here. Mr. Bush, could you help me here? What are your thoughts?
Well, the one thing she wanted the court to know is she was very, very intoxicated, but it's her belief and understanding that she did consume alcohol at the liquor store in the hour gap between when she got there and the police arrived. Not making the argument that she was sober when she got there. That's not what we're saying. There was a lot of alcohol in her system, but it's her belief that some of it was consumed after she arrived at the liquor store. Talking to her, she realizes that she needs to make a major change right now. She's extremely nervous today, which is probably good. She's really concerned about what's going to happen. She is a single mother. She has a lot going on. She's very young. Regardless of when it happened, we always have the guideline, if your blood alcohol level is greater than your age, it's a major red flag. And her alcohol level was way above her age. I'm glad that she's already involved with the pivotal services right now. She seems to be embracing that from talking to her. She's going to have to do a lot to make the changes, but I would ask the court to implement and follow the recommendation.
Tiffany, what were you drinking?
I was drinking MXDs and I think it's a vodka. I kind of can't remember, like how much I drank, but,
What are MXDs?
it's like a mixed drink. They're pretty strong. It's, 12%. And then the, 99 shots, just like little shots or double shots. I think it's vodka.
The only pants you'll want to wear this summer.
Well, you're killing the pain. Matt, what's your thought here?
Well, this is a very difficult case. Ms. Tincher's young, obviously. She's got some issues going on, but I only have an hour to meet with somebody prior to court. There's enough going on here that I can't get everything in. I will say that I submitted this recommendation last week, and then I checked this morning. We had received the substance abuse assessment that I requested from Pivotal over the weekend, and then I added that to the file. After reviewing it,
I didn't see it.
I added it this morning. So
I'm not sure it's in my file.
it should be. It's 28 pages, so I can give you a synopsis of it, but it's very helpful because there's a lot of insight in there, a lot of things that I wasn't able to get to just based on, the logistics.
There, it just popped up.
Yeah, she's fully embracing treatment. It's co-occurring. She's got some stuff. I think perhaps the most helpful extraction out of that assessment is that she's ready to unload all of her stuff. She's ready to deal with some things that she's been self-medicating for. She's admitting this, which is a good sign, especially at her age, that she wants a better future for herself and her child. The case facts are not good. As laid out in the report, there's a dog involved. She's so intoxicated that the convenience store attendant has to call the police and try to prevent her from getting in the vehicle. There's some resisting element as well in this. I'm mentioning purely for the fact of departing from the presumption of fines and costs. I think she was so intoxicated, she doesn't really remember what was going on that day. That's not an excuse for her behavior by any means, but the refusal, in my mind, there's a couple of different ways that you can factor in refusal for a chemical test, right? She was beyond, I think, the ability to even submit to a chemical test. However, the statute is what it is, and she was marked as a refusal, so she'll have to deal with some of those ramifications going forward.
You're gonna lose your driver's license. Is that ramification?
Yeah, I know that.
Given all that I've talked about here this morning, and what I learned from that substance abuse assessment from Pivotal, I had initially made a recommendation for a scheduled day in jail. I think community work service can have the same impact in this, so I'm somewhat adopting on the fly a recommendation I would put in front of the court. I think 24 hours community work service instead of scheduling a day in jail would be appropriate, given her age and lack of criminal history. And then obviously I think that there should be some deferred jail to return back to if Ms. Tincher's not going to take this serious. I think she is, though. I also made a recommendation for the victim impact panel for her to comply with treatment, fines and costs, and a 12-month probation.
Ms. Tincher, anything you'd like to say to me?
Yeah, I just want you to know that I am very embarrassed. I made a really big mistake, and I'm sorry to you, myself, and the officers for the way that I acted that night. And I do want you to know that if I wasn't drunk that night, I wouldn't have acted like that. And that's not me at all. And I don't want to be portrayed as that. Like, I don't want this to paint a picture for me, because that's not me at all. And I don't want to live this life. I don't want to, this is scary for me. I can't. I don't want to be taken from my daughter again. I promise you, if you give me the chance to prove myself to you, you will not be disappointed. And I am sorry once again, and I'm embarrassed.
What's your relationship with your child's father?
It's kind of rocky. Right now, we're like kind of on and off, I guess. We kind of fight a lot. We're kind of
Does he
toxic.
see the child?
Yeah,
Does he pay any support?
yeah, he told me I didn't have to work and he pays everything just so I could be home with her.
So do you two live together?
No, he stays the night sometimes with her so he can see her.
But he's paying all your overhead?
Yes, he wanted to do that. He offered to do that. Because I moved all the way from my home to Three Rivers to be with him.
Yeah, you're from up north.
I'm from Niles, Michigan.
Oh, Niles, all right.
So that was a really big change for me, and I guess he kind of just wanted to help out, I guess, and let me be with her while he works.
What kind of work have you done?
I've done a lot of CNA. I've worked at Walmart. I've been a housekeeper before. I worked at Amazon. I delivered for them. So before I got pregnant, I always had a job.
Do you remember what upset you this particular day?
Well, it was
Breast corrector bra for C.
ongoing. My grandma had just passed. I watched her pass away. She was really bad. We had got into it, and my daughter's never been taken from me, and he took her. So I guess I didn't know how to deal with that, I guess. And then I found out something medically as well prior to this day. So it was just kind of a lot built up, and I wasn't really taking it serious enough. So I guess I just kind of.
Well, you were certainly self-medicating. I'm surprised that you could contain that much alcohol. Did you
I blacked out, Your Honor.
Well, did you get sick?
I don't know. I don't remember anything.
Well, they have to take you to the hospital at 3-2. They did take you to the hospital, but it was not good.
Yeah, I was very drunk. I heard about that, but I don't remember any of that. And I'm embarrassed, honestly.
And Mr. Bush's representation that you drank some more at the liquor store, I think probably is.
Yes, that's why I went there. And
But I think there's sufficient evidence that you were over the legal limit when you got from Javier to Paul's Pantry. But you were difficult for the officers and the hospital staff, and it wasn't good. I am going to do a 12-month probation.
I'm sorry, Your Honor.
I'm going to do a 12-month probation. I'm going to do the original recommendation. 10 days jail. Credit 1. Leaving 9 days to serve. Of the 10 days, 8 are deferred. You got a day to do for all the aggravation of the police, the hospital staff, the people at the store. This was scary for them. I'm gonna make the fine 0. It's normally $300. Right now you don't have any income, but this is expensive. $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee, $480 probation oversight fee. And they didn't do a police reimbursement?
There wasn't one contained in the police report that I obtained from Three Rivers.
Good at that lately. And the victim impact panel is $32. Let's add that up. 125 plus 100 plus 480 plus 32 is 737. When did you last have something to drink?
That night, Your Honor.
All right, so no alcohol since.
I have no drink since that night.
Very good. Very good. You got a 2-year-old daughter that needs you.
I know.
No drugs, no alcohol. Test as directed. You're gonna lose your driver's license, which might not be fair in light of the fact that you don't have a clear recollection of what happened. But as Matt put it, this whole thing went into effect and you have to deal with the consequence of it. Now, there's Kleenexes right there. You're connected with Pivotal, which is the best thing in the whole thing. You've got lots of baggage that you're carrying that you ought to be able to put some of it down. When I see a young woman your age with this high of a blood alcohol level, I know there's childhood trauma. And you're apparently ready to deal with that at Pivotal. And that's more important than any other component of this. And it seems to me that you're sincerely plugged into it. I don't think you're just going through the motions. This is an opportunity for you to address this and make things better. The last lady I just saw, she's older than you are. She was half as much alcohol, but same thing. She was embarrassed. Her car got towed, your car got towed. That's all expensive. She's gonna keep her license. You're gonna lose yours. That's hard when you're a young mother and you gotta drive your daughter to appointments and you're gonna have to go through struggles to get it back. But I want you to stay sincerely plugged into Pivotal and deal with the underlying issues that set this all in motion. I didn't do a probation form here, but I want you to go with Mr. Huff. He will meet with you and get you plugged into this probation. You got a day in jail to do. That's part of the additional consequences.
I went to jail.
You're gonna do one more. 1 day sober, 1 day drunk for the Tasmanian devil behavior. All right, you can go with the court officer. We're back. We're going to shift from civil matters to criminal matters. Abby Stoll has joined us for some sentences. John Bush is here. We've got some other attorneys. We're going to get started. We're also going to fit a bench warrant arraignment in here because Mr. Bush represents the defendant in one of the cases. All right, the first matter we're going to address is People versus Frank Leonard Butts. Mr. Butts was charged with 2 counts of resisting obstructing a police officer. 2 counts of assault and battery and 1 count of resisting obstructing a police officer. He entered a plea to attempted resisting obstructing a police officer and a charge of assault and battery. Mr. Bush and I are senior members of the practicing bar, and Mr. Butts has been around about as long as we have. And this is I don't know, an interesting case, got some odd aspects to it. Mr. Bush has provided Abby Stoll and I with a letter from a neighbor of Mr. Butts regarding some of what's going on. Saw some pictures of some mean looking dogs. Mr. Bush, what would you like us to know here?
Frank is now 68 years of age. He's single. He has no minor children. He's retired. He was on disability, not in the best physical health, and he has a history of mental health. He's taking prescriptions for bipolar and depression and panic attacks. He has issues with his back, rotator cuff. He has a Michigan medical marijuana prescription for THC. He's already spent 4 days in jail in this case. It's too much of a simplification to say it was a misunderstanding. There was clearly a lot of tension that was going on in the neighborhood. I think Frank feels genuinely bad, sorry that he had no idea that the person behind the helmet was a child of that age. And that's one of the main reasons he accepted responsibility for the attempted, or for the assault, because he recognizes that he was put in a great deal of apprehension as a result of this. I think it's important is there was never any touching. In Frank's mind, he was defending the perimeters of his property that was repeatedly being driven over or being damaged by the vehicles from the victim and the victim's family. It's an event that I think everybody would like to do over again. I submit to the court that 2 days in jail is significant punishment for a 68-year-old man in this case. Would ask the court to sentence him to time served. Thank you.
Abby, what's your position here?
Your Honor, I would just let the court know that our office did try to get a hold of the victims. Unfortunately, we didn't hear back from them. I'd also add that I reviewed all of the body cam video and the full police report, and it concerns me that the defendant would become so upset and angry over something so minor. These kids were riding around on their four-wheelers. They turned just slightly into the defendant's yard, which is actually a part of the roadway. It's not the defendant's private property. There was no damage, but he threatened them with a shovel, which is entirely inappropriate. And then on the way to the jail, he was making comments. I'm not sure if you read the police report, Your Honor, but he was making comments about knowing Judge Middleton and that Judge Middleton would understand why he was so angry and would believe him and would let him go, which is also inappropriate. So I would just ask that the court take all of that into consideration, and I would leave sentencing to the court's discretion.
Yeah, he said he knows how to get away with crimes. They're scared of me, and I'm glad Judge Middleton would believe him and understand why he was annoyed by people riding four-wheelers and would let him go. He said he spent 25 years in prison, which isn't correct, and wasn't afraid to go to jail.
I'd like to explain myself if I could, Your Honor.
Yes, and then you were a pain in the neck when you got to the jail and you were drunk. You were 0.150, which is not something we should ignore. You wouldn't have acted this way if you hadn't been drunk. I thought I thought you quit drinking, but apparently not. Yes, Mr. Butts, what do you want me to know?
This whole thing it's already brutal. The neighbors, they moved, they got evicted.
So these neighbors with the four, they're gone?
They're gone. Well, they moved 2 blocks away,
right,
but it's still further than what they were from me. They do continue to come down every once in a while, not late at night. They're not speeding or anything, but Mr. Hudson, yeah, he's a different story. He has come down a couple of different times. revving the motor up, kicking up a bunch of dust. I'm not saying that I'm trying to minimize anything. Like I told my attorney, I didn't know that the little 10-year-old boy was on the moped. They were taking turns riding the quad runner. And first it came across my yard, and then the next time it came down, somebody had a helmet on. And that was when I went out and stood beside my driveway with the shovel. And as soon as he turned around, I could tell he took the helmet off, and I seen it was a young boy. And so I am, because he was afraid, and I'm sorry for that. This has been going on for quite some time. The night of the 15th, or the night of the 16th, or the night of the 17th, take your pick. They were running out 2:30 in the morning.
Are you talking about June?
In April.
Oh, April. Okay.
April 17th, couple of days before my arrest.
Okay.
Actually, it was about 3 or 4 days before my arrest. Every night, 9:30 to about 2:30 in the morning, they're running past my bedroom window with this 4Runner, and I'm trying to go to sleep. And it bothered me. After about the 4th night, I called the police on the 17th, and they came out there and they said, well, we'll go down and talk to him. And I said, I've talked to him. If you don't do something about it, I will. And he warned me, no, don't threaten him. Well, I didn't, and not at that time. And then a couple of days later, it's in the afternoon, and I seen him come down, and a couple of times they went by, and then the next time they come down, they went across my yard, and that was when I went out with a shovel. I didn't mean to resist the officer, but I did obstruct them a little bit, I guess, because they were trying to ask me for information, and I didn't want to talk to them. I called the police about these people. Other people in the neighborhood called the police about them, and nobody was able to do anything. So I decided to take it into my own hands and do what I knew I thought I could get away with without going off my property. Obviously, I was wrong, and I'm sorry for that.
All right, I'd hope maybe to hear from them. Some of this is on a public roadway, and you got 10-year-olds driving motorized vehicles without licenses and other stuff. And so to some extent,
Your Honor,
yes?
I speak in his behalf.
You, Mr. Latchman?
We can't hear you.
Are you Mr. Latchman?
No, I'm Mr. Cerny.
All right. You're here on whose behalf?
Right.
All right. Yeah, I guess so. Mr. Cerny, come up to the podium if you would. And you've been here on some civil matters regarding your neighborhood out there.
Yes.
Near Long Lake. State your name for the record, please, if you would.
I'm Ronald Cerny, 32226 Palmer Street, Colon, Michigan.
You had a nice piece of property there that you've improved and some other related properties.
Yes.
How close are you to where Mr. Butts is?
I'm one street behind him, right behind him.
All right. What would you like me to know?
Well, I even got some pictures here. I realize Frank's been in trouble before. We've addressed that before with you. This Mr. Hudson, I was on Zoom with you through Coldwater. We evicted him. You told me what I had to do that. And he ended up with a year behind on his payments. He took it a turn around. The place is so bad now, it has to be destroyed and put in a dumpster. It's uninhabitable. This Frank finally stood up for a lot of people out there because of this four-wheeler. I know he didn't do some things properly, but we were ready to take up a collection for him to come to court and hire a lawyer. But I got some pictures. I want to give you an illustration of what Frank has done.
All right,
since he's been out there. I mean, he's contributed to the community. His home is meticulous. The neighbors all around him, he don't charge them. He keeps their places meticulous, that whole area, except for this Aaron Hudson's, which I have a picture of Frank's place. I have a picture of something Frank built this summer, a fence, not bought, hand built, that there's people gone around and take pictures of it. It's that great. Frank's a contributor to the community out there. He's not a hindrance and he tries to keep by himself. But in his case, I would have done the same thing. It's day after day, night after night, 1, 2 o'clock in the morning. No mufflers on this thing. And he continues to has to come by just yesterday, last night, come by and harass us again with that goofy thing.
Why don't we take the pictures? Thank you, Mr. Cerny, for being here. No one's here on behalf of them. One thing that I mentioned, he was drunk and he was very disrespectful to the cops. Well, that is a very nice fence. All right, thank you.
Thank you.
I think I've done work for your uncle too.
What's that?
I think I've done work for your uncle too.
Which uncle?
Out on Clear Lake, out there by Clear Lake. His wife had a beauty shop.
Oh, that would be Pleasant Lake.
Yeah.
All right. Well, again, I don't like you dropping my name to the cops just because I've known you in the context of court. But I think I've always tried to treat you fairly.
But you have, sir.
It looks like you are doing a lot better. Your place looks great. I could see why you wouldn't like this. The other neighbors are also aggrieved by this, but it was a 10-year-old kid, and when you sometimes take the law into your own hands, it doesn't go well.
They think everybody's picking on them out there.
All right, well, I'm gonna give you 4 days, credit 4 days on the assault and battery case, concurrent with the attempted R&O. Let me ask again, I thought you had quit drinking.
I do occasionally, and I think that day I hadn't taken my medication.
So you're on
my
medication.
copay is $3, and I had ordered my medication, but because I couldn't.
You're 2 times drunk. You're taking all this different medication. You're not supposed to mix alcohol with it, which is why you were such a fool to the cops, because you were drunk.
Yes, sir.
You were mad and you were drunk. And the kid's 10 years old. You're lucky his dad didn't come over and shoot you or something. Don't take the law into your own hands because it doesn't end up well for anybody.
Well, from here on out, I use my camera. I don't act, I just use my camera.
All right, that sounds safer. Apparently, they were annoying all the other neighbors as much as they were annoying you. But as I said, on the R&O charge, I'm gonna do the same thing. 4 days credit, 4 days. In the 4 days, your life you're never gonna get back. Mr. Cerny did evict these people. There's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. That comes out to $350. You posted a $400, $4,000 10% bond. I keep 10% of the 10%. The bond will cover your fines. You'll get a $10 refund. I don't want to hear any more about this. I don't want you chasing these kids or yelling at them.
It's over.
All right. And I'm glad it's over. All right.
Thank you, Judge.
All right, thank you.
Let's
you go out to the counter and you'll get a little bit of your money back. But
okay, could you contact the sheriff's department and turn my shovel back over to me?
No. You get a new shovel. It's threatening this 10-year-old kid with a shovel. That's part of your sanction. All right, you're good to go. Mr. Bush, I've got Mr. Hostetler here. This is a cold call, but let's bring him in. Good morning, sir. Are you Tyler Lee Hostetler?
Yes, I am.
Mr. and Mrs. Cerny, thank you for being here.
Thank you.
Mr. Hostetler, this is Judge Middleton. I'm here with your lawyer, John Bush. You've got several cases, at least 3, maybe more, that we have to address. This case is 252544SM, charged with domestic assault. The allegation is you assaulted Taylor Weiss. The file is full of you failing to appear when you were supposed to. You last failed to appear on May 1st. You failed to appear for an attorney pretrial. Mr. Bush was here, I was here, the prosecutor was here, you weren't. I had given you 2 days previously for failing, yes, failing to appear. Anyway, when did you get arrested?
I believe it was Wednesday night, Thursday, something like that.
Where at?
At a gas station on 131, outside of the Rivers.
All right. Court was closed Friday, Saturday, Sunday. It's now Monday. I need to get your case back on track. I'm going to reset the attorney pretrial for Judge Patterson's day. My attorney pretrial is until August 7th. He has one on July 17th. John, are you here July 17th? That would be your normal Judge Patterson pretrial day.
Check real quick. Is this a morning one or a 2?
Yes, the morning ones.
That's a Friday?
Yes, let's take a look.
Hey, July 17th, could I do a district court pretrial? I think that's a Friday morning. Thank you, that's fine. I already have 3 that morning, so.
All right, that's what I thought. All right, July 17th at 8:30. You've got 2 other cases that judges are going to see you on, and maybe the magistrate. But this one, I canceled your bond. And I can't do that permanently in a misdemeanor case. Where are you living? Are you still on Lutz Road?
No, right now, I am homeless at the moment.
What, say that again?
I am homeless at the moment.
I'm going to set the bond at $2,500 cash or surety. You previously failed to appear, and I gave you 2 days in jail credit. 2 days. All right, Mr. Bush didn't really have any notice of this. I just asked him if he would do it, but it sounds like you're going to be in custody. You may have some other cases set for that day as well. That's next Friday. And Judge Patterson will handle the pretrial at that time. Your bond is $2,000 cash or surety.
You said 2,500?
2,500, yes, that's what I wrote. For the standard conditions, no contact with the complainant, not leave the state, no other criminal violations. All right, they'll be seeing you again before the morning's up, or at least before the day is up on the other stuff. But this takes care of Mr. Bush's case, and we'll set that for a pretrial on July 17th. All right, Mr. Hostetler, about time for lunch.
Does your office have the alcohol screening reports for the 11 o'clock sentencings?
I don't. I had them on base. Laura can print one for
Okay,
you.
I'll go check.
All right. All right, John Beachy is next. Thank you, John, for helping me fit that in there. This is file 2642SM, People versus John Mark Beachy. This case is a long history. Parties have been here multiple times on this case. The charge was 2 counts of domestic assault. Defendant is represented by attorney Tom Siver. He pled no contest to domestic assault with a deferral. He has been attending domestic violence classes. We were last here in June, and he had nearly completed the program. So it's almost like he entered a domestic violence deferral before he actually entered the plea, and was probably 70% through the treatment before the plea was entered. Plea was entered by no contest.
Which he was required to enter the program and prove that he could actively participate before they would offer it.
So he's completed the program?
I don't know if he's completed it, but he did start it prior to us starting the program, the 4A.
Abby Stoll is here. She, I think, inherited this. Mr. Robert originally authorized it. I've indicated previously, I did know more about this because of a PPO landlord-tenant kind of circumstance. I dealt with the parties. The complainant was very angry. Eventually, she's got out of that tenancy and has moved on somewhere else. Mr. Beachy, how many of the sessions have you completed?
I believe it's I think it's around 8.
Of 10 sessions?
Yeah.
I set this for today. Maybe my timing wasn't very good. I didn't want to keep kicking the can way down the road. He had, as of June 4th, he had done 6 sessions. So I was hopeful that in a month, he could have done the last 4 sessions. Ms. Stoll, what's your position?
Your Honor, I'm recommending 769-4A. It's my understanding the defendant doesn't have any criminal history. And as we've just discussed, he's taken it upon himself to sort of correct his behavior and his mistakes, to learn from his mistakes. Unfortunately, Ms. Sudbury, the victim, isn't here. I definitely know that she would have liked to be here today to address the court. After watching the deputy's body cam, what concerns me, well, it's evident that the defendant has anger issues. So I would ask that he be put on a probation that addresses that. But what concerns me is that he's teaching his children, his sons to act this way. They were acting,
Say that again, the door was opened right then.
he's teaching his sons to act the same way that he does. He's angry and it was an intense situation, but what I gathered after watching the body cam video is that his children are going to have anger issues as well if this isn't corrected now. So like I said, I would just ask that the court put him on a probation that addresses anger management.
All right. Well, I guess the probation would be about 2 months or a month. The way this works, Mr. Beachy, is you enter a plea, which you have done by no contest. The court imposes a sentence with conditions, and if you comply with the conditions, the case is dismissed. It's made non-public as a permanent record of your conviction. So there's no record that you've ever been convicted of domestic assault. The conditions are no further criminal activity, no drugs, no alcohol, and complete the course. You're almost done, but I have to do a probation in order to dismiss the probation. So this is interesting. You've done most of the probation before we even started. His son does have anger issues, and so does he, but there's history. Their mother died in that house, and it was very traumatic on the whole Beachy family, and they're still dealing with the repercussions of it. I don't want to say any more about it, Mr. Beachy, because I don't, but I am aware of the background circumstances. But a lot of effort has been made to try to get this case to the finish line. Mr. Beachy, you did plead no contest, but if you have something that you want to say to me, I'm interested to hear it. Is there anything else you want to say to the court?
It's okay. He wants to know if you want to talk. Judge, my client's been through a lot.
Yes.
You're right. The community does know his history, and they do know the history of the family. And it's never his intent for his young men to see this, but they've been through pure hell. And the court knows that the alleged victim in this used the death of their mother against them, and the family fell apart. And he's struggling with words today to you, but I can tell you he is not the same John Beachy that I met in January.
Well, he's been appropriate every time I've seen him. Mr. Beachy, how many times have you been here? About 7?
We've been here 5 or 6, yes, sir.
A bunch of times. And I'm gonna do a 12-month probation, but you're gonna be able to be discharged as soon as you complete the treatment program. So if you got 2 more sessions to do, when you complete the program, you may be discharged from the probation. So
does he just have to show the clerk's office?
Well, the probation department.
Probation, and then he can do it without motion?
Yes.
Thank you. That means
10 days, credit 1 of the 10 days, 9 are deferred. There's no additional jail if you do what I ask you to do, which you've almost done. Fine is 0. This isn't a fine kind of a case, but there's a $75 crime victims' rights fee, a $50 state minimum fee. There is no attorney fee. You're to pay for the class, which you've done. And the probation oversight's fee is $40 a month. So that's $480. But if you're only on probation for a few months, it'll only be $40 per month. You're to complete the anger management class, no assaultive or threatening behavior, no drugs and no alcohol, and no contact with the complainant, Megan Sudbury. I think we finally got through that. Did she end up getting all of it? You never, you lost your wallet, all your identification, everything was with it. You contend that she had something to do with that. She denies that. I don't know the ultimate answer to that, but I don't have a solution as part of this sentence. But her stuff is all gone, out of storage. You don't have any reason to have any further contact with her. Is that correct?
That's correct, Your Honor.
And this ended up in a weird situation where you had a no contact. You were put out of your own home and she was there with your kids. And that nobody liked that, including her. This is just an unfortunate, regrettable chapter in everybody's life.
Judge, I do have a stipulation to withdraw as counsel for the personal protection order. Would the court be willing to sign that, or do you want that to go to the circuit judge?
Whoever's handling it, Judge Patterson's, I don't know what the status of that is.
It was adjourned pending the outcome of this.
All right. I'm gonna leave that to Judge Patterson.
Thank you.
But maybe you can resolve it today.
Yep.
Probation may be discharged as soon as he completes the DV class.
So he should have 2 more sessions because he's got 8.
Yes, he shared that with his probation officer. He's gonna meet him this morning. And we'll get that. Mr. Beachy, I ride my bike past your house about 3 days a week, about 6 a.m., not much going on at that time. Hopefully this will resolve it. Everybody can move on from here. Thank you. You're good to go.
Thank you, Judge.
May I ask one question, Your Honor?
Yes, sir.
That same evening, Megan actually assaulted me. And I was curious what the prosecutor was doing about that.
I don't know the answer to that. They didn't pursue any charge against her, just this. So I can only address the case that's in front of me.
I've got photos here of my arm that I given the sheriff's department.
I don't know the answer to that, but what I'd like you to do is complete this, get it removed from your permanent record and move on. I can't speak to whether charges were lodged against somebody else. Mr. Robert was the chief assistant at the time. He authorized this. They have information I don't, and I have information they don't, but the answer is I don't think anything's going to come of it, is my guess at this point, but you can take it up with further inquiry with the prosecutor. But why don't you finish this before you move on to anything else?
Okay.
All right. Good luck, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Good morning. We're back from our long holiday weekend. It is Monday. I actually have a couple surprise visitors here. I thought they were on their way back. But we still got a couple of guests. We've got a civil docket this morning, criminal docket starting at 10:30, landlord tenant docket this afternoon, and some small claims. So we got a full Monday after a full 3-day 4th of July weekend where we had a wonderful time. Happy winter in Melbourne. Anyway, it's a beautiful day today too. I've got people in the waiting room ready to go. And we're gonna get started. Had a big storm at my house, big tree down in my front yard. And big storm on the inside with a bunch of kids. But we survived it and it was all a good weekend. So today, it's holidays over, we're into vacation period. A lot of people are off. So here's one. Does not have a happy enchilada in it. I know a guy that's got a lot to lose. He's a pretty nice fellow, but he's kind of confused. He's got muscles in his head that ain't never been used. Thinks he owned half this town. Starts drinking heavy, gets a big red nose, beats his old lady with a rubber hose. Then he takes her out to dinner and buys her new clothes. Fats. All right, let's get started. Thank you all for saying good morning. We kind of jumped right in. I came in early this morning, like I always do, a little after 7 to try to get prepped. And it's time to go to work. Judge Pattison is back, so that's a plus. He also had a good weekend. Got a half an inch of water and you think you're gonna drown. Good morning, Miss McDonald, can you hear me?
Yes, I sure can.
All right, joining us also is Attorney Megan McKelly. I've got you in that little room, and I apologize for that, but it gives me the ability to let you speak privately with the attorney if we need to do that. So let me talk about the case that we're here on. Title of the case is Forsyth Finance LLC versus Lois McDonald. The file number is 251611GC. The claim is for $2,864.54 plus cost, interest, and attorney fees. This debt has to do with money that was borrowed to buy an oxygen machine for your 92-year-old mother. And apparently there were issues regarding the machine. I'm not exactly clear about that. This is the company that financed the purchase of the machine, as I understand it. Ms. McKelly, what's the plaintiff's position?
Yes, Your Honor, thank you. The plaintiff's position is that this loan was taken out to finance a machine. The money was provided on behalf of Ms. McDonald, and today it remains unpaid in the amount of $2,864.57.
Ms. McDonald, what's your position?
Well, I tried to work with the company. The machine.
I'm having trouble hearing you.
Pardon me?
Go ahead. I was having trouble hearing you.
Okay. I put the speaker location.
Well, you're very close to the camera. If you back up a bit. All right. Yeah. All right, now I can't hear you, so there's a happy medium. If you get a little closer.
Oh, okay.
All right. Okay, go ahead. What would you like me to know?
Okay. When the oxygen machine started to malfunction in two different ways, I continued to call the company and they just felt like I was bothering them. And this was important for my mother to have oxygen, congestive heart failure, and it was very important. So what I did was I sent it back to them because it was a refurbished oxygen concentrator.
All right, well, the problem is, this is two different things. This is the company that loaned you the money to buy the oxygen machine, not the company that sold you the machine. Sometimes they're hard to separate, but this is a finance company that loaned the money to buy the oxygen machine. They didn't sell you the machine. And this happens a lot with auto loans. People borrow money from a credit union and they buy a car, and the car is a lemon and they got all kinds of problems with the car. But the loan company didn't sell them the car, they lent them the money to buy the car. And that's a similar situation here. Ms. McKellar, are you willing to speak with Ms. McDonald in a breakout room?
Yes.
I don't doubt that you had problems with this machine. But that may not be a defense to the company that you borrowed the money from. I'm going to put you in a private breakout space. That's why you're in this little conference room, so you can talk privately with the attorney. Now, what you're going to discuss is whether you have the ability to make any payments on this, or whether they would somehow compromise or adjust the debt. If you guys can work something out, that's great. If you can't, you have a right to have a hearing on this, including a trial. But all your defenses about the defective oxygen machine are not really defenses to the company that loaned you the money. So this is quite common. I'm going to let you speak privately. You don't have to settle the case, but she's going to discuss the options of settling the case and your ability to make a payment. If it isn't settled, we can set the matter for a trial. But when you see the button that comes up to say join the breakout room, click on that, and you can speak privately with Attorney McKellar. So do you see it? Click join.
I think I'm in room 1 right now. Is that correct?
Yes. Laura, could you help her?
Yes. Yeah. I'm in room 1 right now. Is that correct?
So you click join. You see it?
The video is breaking up.
Yes.
Is the lady going to join me in room 1 right here?
Yes, hit the button that says join room 1.
Okay, there we go. Hi.
Do you need help?
Yeah, he's ready for the other lady.
She needs to join the breakout room.
Oh, okay, sorry.
All right, people have struggled with that. That lady was quite apprehensive about coming to court. She called a couple times last week. She's about my age. Her mother's in her 90s. All right, we have these about every 15 minutes. I don't know what to say for this poor lady. And I'm not sure how anybody connected the med plan that sold the oxygen machine and this finance company are. I did finally get a new oxygen machine, and then her mother passed a few months later. Next up, we have a 9 a.m. then a 9:15. We did have jury trials set for Wednesday, and we thought we were going to do a joint trial. But the cases were dismissed and one was adjourned. Judge Patterson had the criminal arraignments this morning. They didn't seem too intense. Don't know what kind of weekend we had. I haven't received the jail route. Here it is. Let's see what we did. We have 105 people in jail. That's a lot for us. We were down to like 82. Let's see how many people got arrested over the weekend. The criminal clerk that gives me the bench warrant arraignments is homesick, so I don't know if I have any bench warrants to add into the mix. It looks like some. We had a friend stay with us. She's from Argentina. She was very excited. Sorry about Brazil, Mexico. Hundred and five is a lot of people. The capacity is 165. But we've been well under 100 for much of this year. Some were felony cases that needed to get resolved. And we did get a number of those people out either by completing a sentence or transferring to prison. Well, we'll see. If they bring me anybody. All right, our next matter as indicated is at 9. That's 18 minutes from now. And we have a 9:15 and 9:30 and a 10. If I do get bench warrants, my preference is to do them right away while the public defender is still here. Otherwise, you have scheduling problems trying to fit it in between arraignments and availability of the public defender and then whatever else is on the calendar. It was very hot in Michigan over the holiday weekend. And the water was quite warm. Kind of water that little kids stay in for 6 hours at a time. And Grandpa gets his head sunburned. Trying to keep up with them. Six arraignments, about 30 pre-exams. This is the world's most boringest live stream. It could be worse. You could be in here watching this from the courtroom. Once upon a time, before Zoom, the judge would get off the bench, go sit in his chambers and work on something else while the parties talked in a conference room. Everybody was here live at the courthouse. But that doesn't work that way, and the judge has to stay here to curate the breakout room, at least in our jurisdiction, since I do everything right from the bench. But it could be worse. You could have to fly back to California today. I don't wish that on anybody. The next guy, we were not able to resolve the matter. They filed a motion for summary disposition. And they seem to have a pretty compelling case. And lay people don't well understand summary disposition. Although they get a brief, which explains it generally, that the plaintiff files. I'm on vacation after this week. But each night this week, I'm gonna be picking up tree stuff in my yard. This tree is probably 150 years old and it's gonna have to come down. Just have a seat right here. Right here. All right, Miss McDonald has joined me here in the courtroom. That little conference room isn't the greatest. It's okay for breakout room, but not the greatest. So I think you can see Miss McDonald there. You're Lois McDonald?
Yes.
All right, you've had an opportunity to discuss this matter with attorney Megan McKelly. Ms. McKelly, what's the status here?
Your Honor, we have agreed to a conditional dismissal in the amount of $2,464. And Ms. McDonald will pay $100 a month starting on August 1st and the 1st of every month thereafter.
All right. That'll take about 25 months. Ms. McDonald, did you have an opportunity to discuss this matter privately with Attorney McKelly? Laura, could you help me, please? She's gonna need the headphones.
Kind of awkward to put on, I don't know.
Okay, that's fine. Thank you.
You're welcome. And here's the volume if you need to turn up or down.
Okay. Alrighty. Okay, thank you so much.
You're welcome.
All right, is that better? Can you hear
Way
me now?
better. Thank
Very
you.
good. All right, we've got a hearing assist set up here in this courtroom. All right, Ms. McKelly indicates that they're going to file what's called a conditional order of dismissal. You're going to agree that you owe $2,464. You're going to pay that at $100 per month starting August 1st, 2026. So it'll take 25 months to pay this off. The matter will remain dismissed if you make all of those payments, and it won't show as a judgment. If you're unable to make the payments or you stop making payments, they can reopen the case and pursue a money judgment. But as I indicated, there's a difference between the money that was lent to buy the machine and the company that sold the machine. And it's unfortunate. Apparently you eventually got one that worked, and I'm not sure. And then your mother passed, and now we're paying for a piece of equipment that nobody even uses anymore. Did you hear what I said? You're going to agree to pay this off at $100 per month starting August 1st?
Yes.
And did you agree to that?
Yes.
Did you feel like Ms. McKelly unduly threatened or coerced you to agree to do this?
Well, there was some sternness involved, and I can't be stern back to her while explaining that when I did return that oxygen concentrator to the company, they refurbished them, and then they can send it back. I knew that they could refurbish it, fix it, and send it back out and sell it. That's what their job was in their company, to sell refurbished. So that's why I tried to settle down a little lower with her, down to 2,000 instead of 2,464, just to, because I know they could refurbish that.
All right, again, it's not the company that sold you the unit, it's the company that lent you the money.
Yeah, it was MedPlan Credit was the company, and MedPlan owns the company.
I see. All right, well, you had a contract to purchase this thing, and that's what we're going from. So let me ask again, are you willing to do this, to have this matter conditionally dismissed and make $100 payments each month until the thing is paid off?
Yes, well, I wanted her to consider as well. Yes, I'm willing to do this, but I wanted her to consider that I made six payments in the beginning, but that, there was no give and take here at the end here, and so.
Well, let me ask this: how many payments were you to make to pay for this thing?
Here, payments. There were, let's see, I don't know, it looks like a couple of years.
How much were the payments?
I don't think, I paid different amounts, $75.04 for one payment, $59 for another, $73 for another, $162.
All right, well, that's hard. So you made 6 payments and then you stopped paying because you didn't feel that the instrument worked correctly.
Well, I tried to work with them the whole time.
All right, well, did they repossess the unit or did they?
No,
right.
they didn't want to work with me. They didn't want to hear anything more from me about it. Each time I called them, told them it was malfunctioning.
So who ended up with the unit at the end? You did?
And I sent it back to the company. They had it, they had it.
Then they refurbished it and sent it back?
No. They didn't refurbish it and send it back.
All right, so you made 6 payments and then you sent it back?
Yes, after a time.
I see. So you don't even have it. This is similar to when a car is repossessed. You're paying for a car that you no longer own. And I don't have to like this, and I don't like it. It's medical debt. The companies are very closely aligned. They have a different name, Forsyth Finance, but it's really, they're like this. So they have poor customer service. They send you a product that's defective. You stop paying, you send it back. They don't give you any credit for it, and they sue you under the original contract for the entire amount. So I can see why you have terrible feelings about this whole circumstance. And they aren't willing to make any sort of concession on it. So here's our options. We can have a trial, and they can come in and present evidence regarding your contract and what happened under oath, and you can tell your side of the story under oath. But we're still coming down to a contract to borrow this money. And now your mother's passed, the machine is gone, and you owe this debt, and you don't have a lot of money. So here we are. So are you agreeing to pay this at $100 per month?
I have no choice, obviously, and I will do it because I cannot tolerate this any longer.
Ms. McKelly, anything to say regarding our discussion?
No, I don't really have anything to add. We're happy to proceed with the conditional dismissal if that's how she'd like to proceed. Otherwise, we can proceed with the scheduling order today.
Well, what you said in here, Ms. McDonald, is you got a new oxygen concentrator for your mother. Did you get it from this company or you got it from a different company?
Oh, no, I bought it from a friend. I mean, a friend of a friend. I talked around town and the nursing home is there and everything that.
So you just purchased another one outright?
Yeah, it was used, but it worked.
All right, so I want to make sure we're on the same wavelength. There's a discussion for that amount. You've agreed to pay it, although you're not happy about it. You feel you have no option. You can have a trial. All right, you want to just accept this matter and have it dismissed.
It needs to be completed and out of my life, and I'll pay $100 a month.
All right.
I can't argue. I'm not going to work. I can't, sometimes you can't work with people. Sometimes there's an edge they have over you as an attorney. And my attorney did send the company a letter, and they never answered his letter and never called him. So, I mean, this is just how it goes these days. Sometimes you just can't work with people, and you're going to lose, and you have to pay. And it's a sad thing, and I have to get this over with now, all right? And I'm ready to sign off.
Well, they did reduce it by about $400 plus cost.
Well, my payments I made on this was at least $600, and I tried to ask her if she could accept $2,000 instead, but there was no room for any kind of.
All right, well, let me stop you for a minute. The claim was for $28.64. You're accepting $24.64. That's $400 payments. Did she make some payments?
Yes.
Your Honor, I don't have the transaction history in front of me right now.
I have it right here.
Made payments to who?
MedPlan.
All right, but not since this law. You haven't made any payments since this lawsuit was filed. Is that correct?
No, because I returned the oxygen concentrator to them, knowing that they're in the business to refurbish and sell.
All right. Well, they have reduced it by $400 plus the court costs of. So how does this read? You've got $24.64. Is some of it damages and some of it is court costs, Ms. McKelly?
I was waiving the court costs and attorney's fees.
All right. So there was some consideration. The court costs are $95. Filing fee, $120.45 service fee, plus a $75 statutory attorney fee. The court costs are $290.45, and they reduced it from the claim of $28.64 to $24.64. So they did reduce it by almost $700. $690.45. All right, Ms. McDonald, are you still at the Virginia Street address?
Yes.
All right, they're going to send a copy of this to your address at Virginia Street, showing a conditional order of dismissal that you agreed to these terms and conditions. May they put your signature on that, acknowledging that you agreed here on the record to that agreement.
Okay, thank you.
Is that acceptable?
Yep, that's it.
All right, now let me say something else. If you want to just get this over with, you sell a car or you get a big tax refund or something, nothing prohibits you from paying it early. If you want to just be done with this, you can pay it off. But the total amount is $24.64. And Ms. McKelly will provide a conditional order of dismissal. Do you have any questions?
Yes, I'd like to ask them to not send monthly bills to me. If they will give me the address and account number or what have that, whatever, I can either pay through the bank, or I'll just send them a check. One way or the other. I don't need a bill coming every month from them.
All right, well, there is an address, and you can contact them and probably even set up an automatic payment or something from your bank. Ms. McKelly, you wish to speak to that?
We won't send a monthly bill.
All right, you're good to go.
Thank you.
All right, thank you.
Thank you. All right, good luck, ma'am.
I'm not sure how to turn this off.
Oh, just leave it. We'll take care of it. Thank you.
Thank you, Judge
All
Middleton.
right, it's nice to meet you.
Take
Good luck to
care.
you. All right. Don't have to like it, although there was consideration there. About $700 worth. All right, we've got next Charles Lammers, LVNV funding versus Charles Lammers. Bradley Johnson is here once again on behalf of LVNV funding. Mr. Lammers, could you join us, please? Morning, Mr. Johnson.
Good morning, Your Honor.
Mr. Lammers is here at the courthouse. I'm gonna close out that Lois McDonald room, and somebody else might need it. All right. This is file number 251843GC. It's entitled LVNV Funding versus Charles Lammers. The claim is for $2,202.30. Attorney Bradley Johnson is here on behalf of the plaintiff. We had a hearing on April 11th regarding this matter. Mr. Lammers was here at the court. He was put in a breakout room with Mr. Johnson. They discussed the matter at some length and were not able to resolve the case. So I set the matter for hearing today and allowed plaintiff 21 days to file a motion for summary disposition and the defendant 21 days to answer it. The plaintiff has filed a motion for summary disposition. The defendant did not answer it, and the matter is set for hearing this morning. Mr. Lammers, I told you this back in April, and I'll tell you this again today. Summary disposition is a foreign concept to lay people, to non-lawyers. But I tried to explain it in May, and I'll try to explain it again today. And there is a brief that the plaintiff filed, which also explains it. They filed this lawsuit for this debt. You filed a letter, which we accepted as an answer, objecting to it. That got you past the default, but your letter did not state any defense, and it does not appear to be any material issue of fact. You have Social Security, and that's it, and they can't garnish that. You're correct about that. They can't garnish your Social Security, but it doesn't mean you don't owe the debt. And they filed a brief and they filed a billing history showing that payments were made and bills were sent to your house, and this is the balance due and owing. So they've asked me to order that you simply owe the money. Mr. Johnson, you wish to add anything?
No, Your Honor, I think that sums it up. Thank you.
Mr. Lammers, you wish to say anything else?
No.
All right, as I indicated, we thought back in May that's where this was headed.
If I'm being ordered.
Let me,
Go ahead.
if you don't have any money, you don't have any money. They can't garnish your Social Security, as you've indicated, but that doesn't mean you don't owe the debt. Your circumstance could change. You could inherit some money, you could win the lottery, you could sell some property or do something that gives you money. But I find that summary disposition is appropriate. I find that you owe $2,438. That is the principal balance of $2,202.30, filing fee of $75, a process serving fee of $64.95, a motion fee of $20, and a statutory attorney fee of $75. Total is $2,438.24. Now, you've indicated you don't have the ability to make any sort of monthly payment, which is why we did the summary disposition route. Do you have the ability to make any payment, or you want me to just enter this order and then you can talk with the company? The problem is, if you don't make any payments, the debt continues to grow. It has interest attached to it, money judgment interest, and it isn't going to go away. Can you make any sort of payment on it?
Probably about $55 a month. How I can do that?
That's per month?
Yeah.
Is that acceptable to the plaintiff, Mr. Johnson?
I'm sorry, Your Honor, did Mr. Lambert say $5 a month?
$55, I thought is what he said.
Yeah, that's what I said.
Well, that's acceptable. Yeah, that's fine.
All right, I'll put that on here. Defendant shall pay $55 per month starting August 1st.
Okay, is there a time frame? Because that's when my disability comes.
Well, the law firm Lloyd and McDaniels is located in Troy, and their phone number is here on the order. I find that you owe that amount, and you are going to pay at $55 per month starting August 1st, 2026.
Okay.
You can contact them for instructions on how to make the payment.
Okay, because it'll be money.
All right. Now, what I want you to do is go out to the counter, and the clerk will give you a copy of this order. The number, as I indicated, is on here. You can call them and they can either do an automatic billing or you can send them a check every month.
Okay,
all right, good luck, Mr. Lammers. Go out to the clerk and she'll give you a copy of that order. Mr. Johnson, thank you. He'll contact your firm and set up payment.
Thank you, Your Honor.
All right.
I'm gonna stop right here, and we can pick that back up again the next time Judge Middleton comes back up again. We gained another subscriber, so to the new subscriber to this channel, welcome. Welcome. I hope that you're enjoying the content, and I hope that you are happy here. We're trying to make you happy here. That's it for today, ladies and gentlemen. For now, I say ta-ta and ciao. I will see you again tomorrow for Flores. Judge Flores is tomorrow. So until then, ta-ta and ciao. You all have a wonderful, wonderful evening. I will catch you guys on the next live stream. You all have a wonderful, restful evening. I will see you again soon.